Good evening. Welcome into the evening edition of From Day One. Back to the idiot in court.
What was that?
Your partner was able, you said, you state in your testimony that your partner was able to actually just cuff me without me complying. How did that happen? Explain that to me.
He grabbed one arm, cuffed it, and then you refused to comply. You continued to keep your other arm away from him. You actually were laying on it with it underneath your chest, and he ended up able to roll you over, grab your arm, and then pull behind your back and cuff you without you ever complying.
Yeah. Are these questions going to get me harder?
You also speak in your testimony that you advised me that I was under arrest for boating under the influence. Is that correct?
Yes, sir.
When did you advise me of that?
Before we even entered your vessel, we told you to step out, that you'd be under arrest for boating under the influence, and you stated no, which would be further resistance because it was a lawful order.
No further questions.
All right, any redirect?
No.
Right, thank you, officer. So do you wish the officer to, well, we should probably remove him from the meetings in case there's a trial. All right, so Officer Bourgeois, thank you for your testimony here today and your excuse.
Thank you, sir.
All right, any additional proofs from the people?
No, thank you.
Okay, Mr. McLeod, do you wish to present any witnesses in support of your motion to suppress?
No. Oh, yes, I was like Mr. Belkey.
Okay, Mr. Belfi, you want to come up to the witness stand, sir?
Oh boy. Is this his opposite attorney? This should be
I
spectacular.
believe so, Mikey.
Oh, okay, I'm sorry.
Okay.
That's fine. I forgot. Dr. Belkey, please raise your right hand for me. You
No
solemnly swear that
spoilers.
the testimony you're about to give in this matter will be the truth.
We're a
the
little
whole truth,
behind
and
the
nothing but
stream.
truth, so help God.
Certainly do.
I know some of you have seen it.
And can you state your name for the record and spell your last name for us, please?
My name is Dr. Phil Belfi, and the spelling is Bellfy.
Doctor.
Okay. All right, thank you,
Might as
Dr.
well
Belfi.
Dr.
Mr. McLeod, go ahead with any questions you have.
Mr. Belkey, could you explain to the prosecutor who holds jurisdiction in
Could you give me that one piece of paper?
Hang on, there's an objection here. So, Mr. McLeod,
You gotta lay a foundation.
I mean, you're doing fine in
Yeah,
representing
qualifying.
yourself. I guess I'll sustain that objection. How you need to proceed with an expert witness first is ask Dr. Belfi some questions about his education background in the area, and then the prosecutor will have a chance to do some follow-up questions if they see fit. And then you would ask the court to recognize Dr. Belfi as an expert in a particular area.
This will be fun.
And then
That'll
if,
end it right
if
there
that's
because he's not an
accomplished,
expert.
then you can ask him his opinions in that area. So
Yeah,
why
I'm
don't you go
thinking
ahead
it's
and just start
ceremonial,
asking
like,
a bit about his background.
thugonomics for John Cena.
What is your area of expertise?
I have a PhD in American Indian Studies. It's not called that, but that's what it is. And I am professor of American Indian Studies for Michigan State University. I'm retired now, but I'm professor emeritus of American Indian Studies. And I've also been qualified and admitted to practice tribal law in the Sault Ste. Marie Tribal Court. And my entire academic career has been involved with treaty issues and court cases and those types of things. So I would, I don't want to be real vain about it, but I would consider myself to be an expert, quite frankly.
Okay, Mr. Belkey, can you explain to me who holds jurisdiction over the interpretation of the 2000?
Yeah, I haven't even heard the question. So go ahead and ask.
Explain to me who holds jurisdiction over the interpretation of the 2007 consent decree.
Okay, and now there's an objection.
He hasn't been qualified as an expert.
Okay, so maybe ask, so, well, I guess let me just handle it this way. Dr. Belfi, can you tell us, there's been a question about the 2007 consent decree. Do you know what that is?
I most certainly do, yes.
Can you tell me what that is?
The state of Michigan and the federal government had a court case called US v. Michigan that dealt with fishing rights. And Great Lakes commercial fishing, more or less. And there was always a question about the inland rights that was not addressed during that court case. And the court case took a long time, et cetera, et cetera. But when Mike Cox was the Attorney General of the state of Michigan, I can't remember what year that was.
Hang on, but you're kind of telling me your thoughts about it. I'm
No,
asking
not
just in
that.
more general. So this is a consent decree between the state of Michigan government?
The consent decree is three parties. All the tribes in the 1836 treaty area, the state of Michigan and the federal government, they all came together to sign that consent decree in 2007.
Okay, and what's your familiarity with that decree? Have you read it, studied it? Have you taught it as a professor? What's your familiarity with that?
Not the same.
All of the above,
Undisclosed location.
yes. And it became that and other issues, of course, became part of my dissertation. So I've studied all of that very,
Okay,
very deeply.
all right, go ahead, Mr. McLeod.
I guess is he qualified?
I'll stipulate to his qualifications.
Okay, in what specific area then? Well, I guess the court would recognize Dr. Belfi as an expert witness in the area of Native American studies, to offer his opinion in that area as pertaining to the 2007 consent decree. Okay, so go ahead, Mr. McLeod.
Could you explain to the court who holds the sole jurisdiction over the interpretation of 2007 consent decree?
Okay, and I'm taking it out of my memory. You got the piece of paper there. It's the first area of the consent decree talks about jurisdiction. And then there's
mean,
three paragraphs
I'd
there.
object.
And Paragraph 1.2 lays out exactly who has jurisdiction over the interpretation, et cetera, of that consent decree. Anything that has to do with
There's no way on God's green earth that he's an expert offering conclusions of law without being an attorney. I'm sorry. There's just no way. I prosecutor's just letting it go, apparently. I don't know, just because he just wants to get out. It's not going to go anywhere. It's all pointless. Maybe that's the faster approach. But this guy is not an expert in the area that he's about to offer an opinion in.
consent decree, when it's being questioned, the only people that have control over that is the federal court in Grand Rapids. They're the people who did the original fishing rights case, and they also did the consent decree and negotiated all that process. It took many years to do all that. And so they retain jurisdiction over everything that deals with that consent decree. So if there's some mention in the decree about you can not have, I don't know the number of it, but you don't need to have your boat registered if you have fishing gear on the boat. That's in the consent decree. And if there's an interpretation that needs to be done on that question, then it has to go to the federal court. They have the jurisdiction. And I don't want to say anything disrespectful about the prosecuting attorney, but that's not part of his role. That is it's a federal case, it's a federal consent decree. The state of Michigan agreed to it. In other words, they agreed that the federal court has jurisdiction over the interpretation. And everything that's in that decree is under the federal jurisdiction. So, it's not my position, of course, to say whether or not Mr. Juliet can
Sure. So, Mr. McLeod, are you,
Let's see if that is an exhibit.
okay, so this is the cover page and page 7 of the consent decree. We staple this and mark this as a proposed exhibit for defense 1. Mr. Juliet, if you had a chance to see that?
If I could just briefly take a look at it.
Yeah, defense one.
Oh,
And I
there,
think Mr. McLeod is offering that exhibit into evidence. Any objection?
No.
All right,
There's
exhibit one
no doubt.
is admitted. And it's the cover page of the consent decree. And page 7 of it, which does have jurisdictional paragraphs indicating that the court shall retain jurisdiction over the parties and subject matter of this action to enforce the decree to resolve disputes arising under it. Okay, continue, Mr. Clark. Okay, any cross-examination?
Yes, you said you've taught taught classes on the consent decree before.
I did not teach a class on the consent decree. I mean, there's no such thing. But I did, half of my load at Michigan State University was involved with Native issues. They let me teach half of my load in Native American Studies courses. And every course that I teach in Native Studies, the beginning of every course is the treaties and the discussion about the treaties and the treaty rights. So the fishing rights case and the inland consent decree, they're an integral part of everything that I do.
Okay. I take it you've read the consent decree.
I've read this consent decree several times.
Okay.
I have to be honest though, when it talks about how many fish you can take out of a particular lake, I don't have that in my mind. But all of the preliminary stuff, all the arguments that deal with individual rights under the consent decree, I know them very well.
Okay. So you know that a tribal member who is subject to certain requirements does not have to present. He must possess evidence of fishing or hunting or trapping gear to shield himself from that registration requirement, correct?
The language of it, and I don't remember the number, and I don't know if Trevor might have a copy of the page.
24.4.
24.5. It says that the boat, it doesn't have to be like putting the pole in the water, but there must be fishing gear on the boat.
Okay. And so they just simply have to possess it.
They simply have to possess it, yes.
Okay.
That's what the consent, that's the language of it. And I should give a little bit of an aside. As part of my research, I talked to people who negotiated the consent decree. It took them 4 years to sit on the consent decree. The reason it took 4 years to do that is because literally, this is how it was told to me, every word had to be discussed. Do we put the word shall or do we put the word may? That might take 2 weeks to figure out.
Oh,
hey,
sweet
is
Jesus.
that word we're going to use? Which one are we going to use? What's the consequences of this? Because this is an important issue. It's a treaty thing, so it's at the
No,
top of the
he's not.
list. Treaties are the supreme law of the land. So when it came to the word possess, I'm going to assume that that's what they meant. You have to have a fishing pole in your boat, a net, or whatever it is that you're going to use for your fishing. It's got to be in the boat someplace.
Okay. Thank you. Your Honor, I have no other questions.
Do you have any additional questions for Dr.
I don't.
Hey, Dr. Duffy, I have a couple. So you say that you serve as a tribal advocate and sue tribal courts, correct?
I no longer serve there because they revoked my permission, which is, quite frankly, is still under dispute.
Okay, but you have in the past.
I have in the past, I have the documents.
Do you have familiarity with how the tribes that are parties to the consent decree have implemented the provisions about boat and vehicle and snowmobile registration. In other words, my question is, do the tribes issue their own registration for any of these vessels, or?
Not that I'm aware of.
So,
Well, he's got a load of something going on.
so in your, have you represented in tribal courts, object to what?
So you're trying to interpret the consent decree.
Oh, I'm not trying to interpret the consent decree. I'm asking Dr. Belfi his opinion about it. Just, the court is allowed to ask questions. So Dr. Belfi, the tribes don't issue registration for vessels?
Not that I'm aware of, no. But they do issue, if you're a tribal member like Trevor, they issue you cards
Yes.
that show that you're a tribal member, you have the right to do whatever it is that you get a permit for.
All right, do you have any knowledge about,
Judge, the tribe issued him a card saying that he can drive a boat drunk as much as he likes. Okay? Stop asking questions.
if non-tribal law enforcement sees a vessel with no registration or expired registration, do you have any experience or knowledge based on your studies of the consent decree about how that's handled, how law enforcement is supposed to recognize if something is a tribal vessel not subject to it, or a non-tribal vessel subject to it? And if you don't know, that's fine. Maybe that's a question for me to ask the parties' arguments, but if you have any knowledge about that.
I do have some knowledge in that, yes. If the non-tribal law enforcement officer can drive, the instant that that person or anybody discovers that the person is a tribal member, that's when the jurisdiction ends. According to everything that I've read and everything that I've learned, when it's cross-deputization arguments.
This is interesting, though. On a side note, this is where the more sovereign citizens, where some of them go the Native American route because they want in on this treaty grift. I mean, it doesn't work, but this is the game they're trying to play. There absolutely are set-asides for Native Americans. I remember growing up, they could gill net fish. It was very controversial because they just wiped the lakes clean of fish, and everybody else couldn't do it. So they absolutely have special privileges, but I don't think that they can just drive boats drunk.
If, for example, Trevor was taken downtown or taken to this building, I suppose, people who were in the building, presumably, knew that he was a tribal member. It was at that moment that the jurisdiction transfers from this particular court to tribal court.
He is not qualified to
That's what the
say that.
cross-deputization is all about.
All right, thank you.
Why the prosecutor is
Any
not
further
objecting, I
questions?
do not know.
Question, Mr. McLeod.
No further questions.
Objection, move to strike. Not calls for a legal conclusion that he's not an expert to provide.
Mr. McLeod, do you have any additional witnesses you wish to present or evidence?
No, thanks.
All right, anything else, Mr. Julia? No, thank you. Mr. McLeod, it's your motion to dismiss. I have reviewed your motion and your reply to the prosecutor's response, but now you also have an opportunity to make any argument you want in support of your motion.
I'd like to submit this. I was told to play a disc for the court today. So I brought it with me.
What is that?
It's a video of me being on the boat and the officer stepping onto the boat and me putting my hand.
Is that like, is there body cam footage?
No, it's a Snapchat that one of my guests filmed.
Has the prosecutor had an opportunity to review
Yes,
that?
they've had it since September.
Okay,
I'm on a boat, Judge.
any objection to that? being admitted.
Then I stepped off the
So if
boat.
we can mark that as defense exhibit 2.
Snapchat of me stepping off the
Hands
boat.
up.
I always do it like I'm drunk. Ah. This is absolute gold.
Well, what we could do is could take a 5-minute recess for me to.
Well, can I submit this along with it? So
I
we
hope
take
he has
some
a
recess?
sombrero
Well,
on.
what is that?
This is part of Officer Bourgeois' testimony from my preliminary hearing.
Well, I have the transcript. You can just tell me what page.
It's
it comes
page 16 and it's line 7, 8, 7, 8. Well, there's other lines in there, but that's the main one I want you to look at.
from. Okay,
Line 7.
page 16, starting at line 7, the court can take judicial notice of the records in the court file, including the preliminary examination. So you want me to kind of view the video in context for this testimony and compare the two?
Yes.
Okay, so what we could do is I can take a 5-minute recess. I can't play it on this computer, but I'll go and watch it and come back. in 5 minutes. Thank you.
Oh boy, here we go.
All right, thank you. I've had a chance to watch Defendant's Exhibit 2 and compare it to the testimony of the officer on page 16 of the preliminary examination transcript. Mr. McLeod, go ahead and make any additional arguments you want in support of your motion to suppress.
Well, I think that we need to impeach that whole officer's testimony because he's clearly lying from the facts of what happened that day. And he's lying under oath, which is perjury. So that's my motion is to impeach everything that he said.
All right, thank you. Mr. Juliet?
I guess I would just first take note that this is what I view as a motion to suppress based on a unconstitutional stop. The case on point is Terry versus Ohio, which states that a temporary investigative detention may be based on reasonable suspicion that an officer observes unusual conduct, which is the officer reasonably.
For the record, you
in light
could.
of his experience, that criminal activity may be afoot. The officer testified that he was on patrol on the Sheboygan River, that he observed the defendant's boat registration to be out of date. Upon further observation, he observed what he testified to be signs of intoxication. I think that alone satisfies the reasonable suspicion test. As to the
I object, and the reason why is because I'm showing that this officer, his testimony can't be trusted.
Okay.
So how can we trust the fact that he's saying I observed this or I observed that when he's lying?
Okay, and that's more in the form of a rebuttal argument than an objection. So Mr. Juliet can make his argument, and you as the moving party, you'll have a chance to make a rebuttal argument.
So just as to the inland consent decree, I did misquote in my original response that the defendant must present evidence. I did submit a amended response. He only needs to possess that evidence.
Change the word.
When the officer made contact with the defendant, he had no idea he was Native American. He didn't see any fishing gear or anything like that. So I don't think that the inland consent decree really shields the defendant in this case.
Well, can I ask you, so do you concede then? So let's say they make contact with them and they learn that he's a member of the, are you a member of the Sioux tribe? He's a member of the Sioux tribe. They can't write him a ticket for the unexpired, for the expired registration, correct?
Well, I can answer that in two ways. Based on my understanding is that he would be shielded from civil infraction ticket if if there's possession of some sort of fish gear or something like that. But based on Dr. Belfi's testimony, I think that unless the DNR officer has some knowledge that he's a member of a Native American tribe, I don't think that can be imputed to the officer to just automatically know that he's a member.
Okay. Can I ask you, have you seen this 6-second video clip?
Yes, I have.
What am I to make of the fact that that appears to depict something different from what is described by the officer's testimony at page 16?
Well, I don't think it describes that at all. I mean, that's a video that they're on the dock. The R&O happened in the boat. So
No, this is in the boat, and the video shows Mr. McLeod standing there talking to the officers, engaged in some conversation with them. The officer steps aboard, stands behind him, and grabs Mr. McLeod's hands, and both hands are being brought behind his back, certainly by the officer, but with no apparent resistance from Mr. McLeod.
okay. Well, to that, if the court's gonna, I guess, ask that question, that's a question of fact, the right to resist an unlawful arrest at a jury or bench trial.
No, I'm saying I didn't see any resistance.
Or
There's
refusal.
testimony that he did resist. I mean, the video is only a few seconds long.
Thank you. Mr. McLeod, any rebuttal argument?
Like Mr. Belfi testified, this document's not open to interpretation by anybody in this room. It has to go to the Western District of Michigan. And certainly not Mr. Juliet has any qualifications to make any interpretations on this document. Without some consent decree.
Thank you. Well, Mr. McLeod has filed a motion to suppress the evidence because of essentially an illegal stop or search or seizure. Some of his arguments sort of blend into a motion to quash for lack of evidence as well. In terms of the suppression, so there is evidence in the record now and testimony about this 2007 consent decree, and that Mr. McLeod is a member of a tribe that's a party to that consent decree that would shield him from prosecution for or from laws regarding registration vessels if he possesses evidence of fishing or whatnot. We're not here on an expired registration matter. If we were, Mr. McLeod may well have valid defenses to that. What we have is a non-tribal law enforcement officer sees a vessel underway on navigable waters and sees an expired registration date. So I think that gives the officer reasonable suspicion to make contact with the operator of that vessel. And that's consistent with Dr. Belfi's testimony as well, that they can make the contact, and then as soon as they know there's a issue, then, at some point, that their jurisdiction to enforce that, may divest. And I understand Mr. McLeod is saying, well, they never gave me an opportunity to tell them that because we're right in the middle of it, right from the initial contact. But be that as it may, I think the testimony, including from Dr. Belfi, is law enforcement, they don't know if something's a tribal vessel or not, whether it's operating under this consent decree or not. They see a vessel on the waters of Michigan with an expired registration, they're allowed to make contact with that person, find out what's going on. The officer did testify that even before making contact with Mr. McLeod, they observed what they thought to be evidence of impairment. So that's the initial contact is not a constitutional violation, nor is it a violation it doesn't appear to be a violation of the consent decree either. They make the initial contact, and there's evidence of the impairment right there. So now they're beginning an investigation for impaired operation of a vessel.
Well, I object, Your Honor. I want you to take a look at the MCL, that the Michigan compiled law that has to do with this OWI on a boat.
Oh, yeah, that you're not, that you weren't
Section-
operating.
Yeah,
Yes,
it's docked.
and I've reviewed that argument that Mr. McLeod says he wasn't operating, and he's correct that he wasn't operating the vessel at the time they made contact with him. You're right,
Yeah, it was docked and tied off, shut up, keys robbed.
but they did, the
Well,
testimony.
I object to the testimony being valid. They're lying. I've got proof of it.
Well, I've heard the arguments, I let you make your arguments, and now I'm making my ruling. The, lost my train of thoughts. That's
You're
right. So they don't, at the time they make contact, Mr. McLeod is not then operating the vessel. But they did testify that they saw him observe it, that he's at the helm, it's under throttle, because the flow of the river would mean that it would have to be under throttle to approach the dock in that direction. They saw him with his hand at the helm and at the throttle. So they observed him operating.
They observed me operating with a beer in my hand or drinking.
It's true.
But,
Can I just
and also,
explain to you, I need to make my ruling. I need to make a record without this just back and forth.
okay, but I want to make part of the record too, is that we were sitting at that dock drinking alcohol and beer before those guys pulled up to us. So there's no way they can determine them.
Okay, well, that's a different issue. You know, doing this one at a time.
Shut up, Chief Running Mouth.
So that they're allowed to, they observe him operating the vessel. They're allowed to make the initial contact because of an expired registration. Before, as they're making that contact, they see evidence of some impairment and begin an impaired operation of a vessel investigation. That's all lawful. And so for that reason, the motion to suppress evidence for an unlawful stop or seizure is denied. And to the extent it's a motion to quash the information or dismiss because of lack of evidence of resisting or lack of evidence of operation, you know, there's at least probable cause of that to support the bind over from the testimony. He's resisting
If you can
the commands to leave the vessel. They do complete an investigation.